Welcome back. This is The Firm. Last year, the U.S. Securities Exchange Commission, or the SEC, settled 714 cases, the highest number of settlements in 7 years. A settlement or a consent order is when an entity, a company or an individual settles allegations made by the regulator without admitting or denying guilt. Settlements are often accompanied by sanctions and penalties. Weak evidence, immediate sanctions, speedy resolution, no litigation costs. These are all reasons why settlements are a popular route with regulators. But nowadays, settlements are an increasingly unpopular route with courts and the public. That pressure has now forced a big shift in SEC's policy. Last month, SEC Chairman Mary Jo White said that the regulator will now require companies to admit guilt in certain cases. This comes barely a year after former chairperson Mary Shapiro said people won't settle with us if they have to admit wrongdoing. So is this new SEC settlement policy going to work? And how? Vaishwani Upadhyay finds out.
In 2005, Bank of America settled with the Securities Exchange Commission for fraudulently timing the market. It got a $375 million bill. In 2007, the banking giant paid $26 million to settle SEC's claim that the bank misused its own research reports. 3 years later, it settled with the SEC against a claim of bid rigging in the municipal bond market. Keeping Bank of America company in 2010 was Goldman Sachs. Accused of misleading investors in a subprime mortgage product, Goldman settled that claim for $550 million. 2 years later, it paid $12 million to settle SEC's allegation of inadequate disclosures in its bond offering documents. Another repeat settler, Citigroup. It agreed to a $20 million settlement in 2005 regarding mutual fund sales practices, a $208 million settlement the same year against claims of misrepresentation as transfer agent for mutual funds, and in 2010, a $75 million penalty for settling charges of misleading investors about the bank's exposure to subprime mortgage assets. In such settlements, alleged offenders do not admit or deny the violation, but they do pledge not to break the law. And yet, a New York Times study revealed that in the last 15 years, in at least 51 cases, 19 Wall Street firms had broken anti-fraud laws they had previously agreed never to breach.
I think it could have done so in a different way. For example, in the Citigroup case, Citigroup was or is a recidivist, and it already had these prior cases where all the SEC had to do was bring a case under the previous one and try to hold Citigroup in contempt because there was an injunction against them. And so if the SEC had brought actions through this injunction of past violations, I think that would have had a much greater effect on reducing recidivism and reoccurring illegal behavior.
I think it took into account not only the culpability of the actor, but also the limited resources they had available to enforce. The SEC is understaffed, overworked, and under-budgeted, and because of those constraints, they needed to settle without forcing the defendant to acknowledge that it had engaged in any wrongdoing. And that elicited a great deal of criticism from judges, from congressmen, and mainly from newspaper editors, all of whom were saying that the SEC was using such weak sanctions that they were either equivocal, ineffective, or at worst irrelevant.
The headline case was in 2011 when U.S. District Court Judge Jed Rakoff rejected SEC's $285 million settlement with Citi. Judge Rakoff criticized the SEC's neither admit nor deny settlement policy as hallowed by history, not by reason. In Citi's case, it held the settlement as neither fair, nor reasonable, nor adequate, nor in the public interest. Perhaps taking a cue from that, a year later, federal judge Richard Leon rejected a settlement proposal between IBM and SEC over FCPA violations. This year in January, District Judge John Kane refused to ratify a settlement between two individuals and the SEC. He said penalties cannot be approved against a defendant who remains defiantly mute as to the veracity of the allegations against him. A defendant's options in this regard are binary. He may admit the allegation or he may go to trial. When SAC Capital tried to settle insider trading charges 2 months ago, federal judge Victor Marrero first rejected it, saying that there is something counterintuitive and incongruous about settling for $600 million if the company truly did nothing wrong.
The judiciary has somewhat of a unique problem where, such as the Citigroup case, the SEC had 2 parallel cases, one against the company Citigroup and one against the individual Stoker. Now, it alleged different conduct for those different individuals. For the company, it was negligent, and for Stoker, it was purposeful and intentional. And that is more of the issue that Judge Rakoff had issue with, was because the public doesn't know what happened. It's not aware of what the company did, if it was negligent or intentional, and when you have these controversial findings of these different cases, then those are the kinds of things that the judges are having more trouble with.
Settling and not continuing to have the cost of litigation with the government and the certainty of where the company is and being able to move on has really, in large part for investors, that settles the question. For the investing public in general, and the citizens at large, sometimes there's an interest in knowing more about what happened, which would come out during the course of litigation, and certainly some in Congress and the judiciary have wanted to know more about what was going on, and so that has caused some to want the policy to be changed.
The changes began last year when SEC amended its settlement policy. It laid down that defendants who admitted to or have been convicted of a criminal offense will not be allowed to settle parallel civil proceedings without admitting guilt. But the bigger shift came last month when the SEC chairperson said that the Commission will try to extract admissions in select cases in which there is widespread investor harm, egregious intentional misconduct, or attempts to thwart an SEC investigation.
Egregious can be defined in many different ways. It's almost like how the court defines obscenity here, where you'll know it when you see it. And so the egregious standard that they've set forth is very vague and gives them a lot of control over what they think is egregious and what they don't. But I think maybe what they have overlooked is that the public might view something as egregious and want the SEC to require admissions, and if it doesn't, it's going to have a lot of criticism and scrutiny now for each case that it either does or does not require admissions.
One of the problems with settling to the SEC on an admission basis is twofold. One is there's the possible loss of insurance coverage. Insurance pays not all, but a lot of the cost of defending yourself in an SEC investigation, and when private parties and investors sue your company. Insurance pays for a lot. If you admit to fraud or wrongdoing, some insurance policies will not cover you. Secondly, if you have to admit to the violations with the SEC, that makes you very vulnerable in class actions that are brought against companies for some of the same violations that the SEC sues them for. So it will settling actually on an admission basis will open you up to potentially more liability outside of the SEC case, which is why some companies will choose to litigate with the SEC.
I expect defense counsel to negotiate in great detail. I could imagine a defense counsel acknowledging that there was a material omission made in a corporate statement, but denying that it was made with an intent to defraud. That's the kind of distinction that I expect lawyers to negotiate at some length, but you would still get an admission that something was done that was improper.
People won't settle with us if they have to admit wrongdoing. Our goal is to maximize the return to investors. If we had to litigate every case, we would bring a lot fewer cases. That's former SEC Chair Mary Schapiro speaking last year.
Your
SEC's former enforcement director Robert Khuzami said in a congressional testimony that settlements serve the twin purpose of speed and efficacy, especially given that it takes a US federal court anywhere between 19 to 44 months to dispose a civil case. Could this shift in settlement policy jeopardize all those gains?
Certainly, if the SEC uses this policy more broadly, this will have an impact on their ability to bring other cases because they will have resources tied up litigating the matter that that they otherwise might have settled. So I believe that Rob Khuzami was correct when he said that this could be a resource drain on the SEC. And that's also why I think that the SEC will use this new policy in very limited circumstances. I simply don't think they have the resources to use it more broadly.
An understaffed, overworked and under-budgeted SEC. Experts say that these factors may undermine this new settlement policy. We raised the same concern last year when SEBI put several offences on a do-not-consent list. But regulators everywhere are under severe public pressure to get the bad guys. It will be interesting to see how SECs admit or litigate policy fares. In Mumbai, Payasri Upadhyay.
With that, it's a wrap on this edition of The Firm. Do send us your feedback on Twitter, on Facebook, on LinkedIn, on email, whatever you prefer. We'll see you next week.